Okay, my name is Wani, and me and my teammates will be talking about the duty to disclose. I have with me Praveen, Kelvin, Kingsit, and Oyin Bolade. These are my teammates. Today, me and my team will be talking about misrepresentation in terms of the duty to disclose. When we're talking about the duty to disclose, we're talking about vitiating factors. And the duty to disclose overlaps with the doctrine of misrepresentation and mistake. And these vitiating factors, if proven to be true, can be a ground for a contract to be voidable. Most common law jurisdictions do not impose a duty to disclose. And this is because of a very fundamental concept, which is known as caveat emptor, or let the buyer beware. This can be contrasted with the Islamic equivalent, qiyad al-ayib. Well, the principle of let the buyer beware, or caveat emptor, is rooted firmly in the idea that parties should be able to contract freely, and if you are the contracting parties, you have the duty to at least check for defects in an item before purchasing it or contracting to buy it. The question that then comes to mind would be then, when courts do not impose a duty to disclose, what might be the underlying factors that we might identify? Well, we have identified two issues. The first one being that fraudulent claims would increase, and the second one would be that somebody might benefit from their own wrong, which would be a case of unjust enrichment. Before my teammates delve into the topic further, one common concept that would come up frequently in our presentation would be that of fiduciary duties. The very definition of fiduciary duty is that it is a standard that is higher than those trodden around by the crowd or public, which is a very high standard. And what a fiduciary duty is, it is that it is a duty of undivided loyalty. Then you might ask, is there a list of fiduciary duties? Well, the answer is simple and clear, that the list of fiduciary duties are not closed, and it is a flexible approach that courts take when defining fiduciary duties. It is one that the courts would mold around the required legal framework or situation in creating or defining what a fiduciary duty is in these circumstances. In this presentation, we'll be focusing on the duty of disclosure in terms of misrepresentation. The question that comes to mind would be then, what is the English stance on the duty to disclose? With that, I'll let Kelvin answer my question on whether there's a general duty to disclose.
In English law, there is no general duty to disclose a material facts because the action in misrepresentation requires some form of expression statement to be made. For example, in the case of Fletcher and Krill, the defendant applied for the position of the governess without revealing that she previously married. The court held that her non-disclosure did not amount to misrepresentation. However, there are some exceptions. In certain circumstances, non-disclosure would find to amount to a statement. The law imposes a duty on the party to say something. If he failed to do so, it may amount to misrepresentations. The first situation, conduct. If an implicit statement made by a party, conduct, turns out to be untrue, then it may be a misrepresentation. For example, in the case Spice Girl Limited and Aprilia Service, the defendant, a member of a pop group under SGL, did not disclose her intention of leaving the group before they signed a contract with the claimant, and her conduct conveyed the claimant that all members would attend into the contract. the court held that the defendant had the duty to disclose the fact because the claimant relied on her conduct as a statement. The second situation, half-truth. The fundamental facts which are the inducement of the contract must be disclosed by the party, as stated in the case of Disclose and Taylor's. If partially non-disclosure, the court in the case Pig and Gurney held that half a truth will sometimes amount to a real falsehood. It is a misrepresentation. The third situation, change in circumstances. In the case of with an offendant, the court held that before the contract was concluded, any change in the circumstances known by either party has the duty to disclose it to the other party. The fourth situation, contract of arbore vitae fide, or called contract of utmost good faith. The most common example of this type of contract is contract of insurance. The parties are obliged to disclose any information which a reasonable person thinks are relevant, even if it is not asked for. If the parties fail to disclose any information relevant to the risk, the insurer are entitled to rescind the contract. For example, in the case of Lambert and Cooperative Insurance Society, Justice McKenna held that the insured is under a duty of disclosure even though the extent of the duty is the matter of controversy. The fifth and last situation, fiduciary relationship. In a fiduciary relationship such as solicitor-client relationship, trustees-beneficiary relationship, and principal-agent relationship, the parties who owe the fiduciary duty obliged to disclose any relevant material facts because another party puts special trust, confidence, and reliance on him and is affected by him to act for the benefit. A fiduciary should not take any chance which might put himself in a place where there may be a conflict with his beneficiaries. In the case of Item Software Limited and Tashihi, the plaintiff, a sales and marketing director of the dependent company, failed in negotiation and lead to the termination of contract between dependent company and Isograph Limited. However, the plaintiff secretly approached to Isograph Limited and made a contract with them. When dependent company discovered that, they sued plaintiff for non-disclosure of his misconduct. The court held that the plaintiff was liable because as a director of the company, the plaintiff has fiduciary duty to the company. Hence, he had a liability to act in the best interest of the company and to account for secret profits. Furthermore, he had a duty of loyalty to disclose his own misconduct as a fiduciary. That's my part. Thank you. I finished my part in English position, and then after this, Sid will deal with
The general rule in Malaysia is that mere silence or non-disclosure does not constitute fraud, but there may be certain circumstances under which such silence or non-disclosure may constitute fraud. This is reflected in the explanation to Section 70 Contracts Act 1950. Mere silence as to facts likely to affect the willingness of a person to enter into a contract is not fraud, unless the circumstances of the case are such that it is the duty of the person speaking, keeping silent to speak, or unless his silence is, in itself, equivalent to speech. The first exception is where there is a duty of the person keeping silence to speak. This often occurs in sale and purchase transactions. The relationships between the party is more than the ordinary relationship of seller and buyer. In the case of Karupanan Chelapan and Chong Li Chin, it showcases the principle of caveat emptor, otherwise known as let the buyer beware, as there is no duty for the vendor to speak. As the relationship between the parties were not more than the ordinary relationship of a seller and buyer, this applied principle is contained in Section 14 and Section 17 of the Sales of Goods Act, 1957. Thus, it was held that caveat emptor applied to the plaintiff as that there is no fiduciary relationship between the vendor and purchaser. Thus, an uncommunicative vendor cannot be faulted if he failed to disclose any patent defect such as the window protrusions found in the instant case. Second exception is where silence is in itself equivalent to speech. Illustration C to Section 17 shows how the second exception operates. B says to A, if you do not deny it, I shall assume that the horse is sound. A says nothing. Here, A's silence is equivalent to speech. There are three elements required for silence equivalent to speech to be established as a fraudulent misrepresentation. The first element is there must be an intention to deceive. This element distinguishes fraud and innocent and negligent misrepresentation. This was affirmed by Justice Ian Cheng in the case of BP Sabah, Sdn Bhd and Syarikat Jubilee Enterprise, where a person is deemed fraudulent if he acts with the intention to deceive someone, and by doing so, an advantage should accrue to him, or injury, loss, or detriment should befall some other person. The two other elements can be found in Section 17, subsection B of the Contracts Act 1950. The second element is that there must be active concealment of a fraud, and the third element is the concealment must be made by a person with the knowledge of fraud. These elements are important in contracts to fide, or contracts requiring good faith, such as insurance. A failure to disclose material facts amounting to fraud will make the contract voidable, at the option of the innocent party by virtue of Section 19, subsection 1 of the Contracts Act 1950. In the case of Tay Say Ching and North British and Mercantile Insurance, defined material facts into physical and moral hazards. Physical hazards are factors that contribute to the likelihood of loss. Moral hazards are factors that throw doubt onto the insured's integrity. Usually for insurance claims, insured typically put forward an inflated claim with the intention to defraud the insurers. Such a claim can be defeated by the insurer on the basis of the insured's failure to act in good faith. Under the Malaysian Insurance Act 1966, Section 150, subsection 1, the insured have to disclose material that are relevant to the licensed insurer. In certain circumstances, fraud does not make the contract voidable. The exception to Section 19 is that silence equivalent to fraud will not render a contract voidable if the other party whose consent had been induced had means of discovering the truth with ordinary diligence. My friend here, Belade, will explain the similarities between the Malaysian position and English position.
Alright, thank you, Sid. I'm going to explain the possible similarities between the common law and Malaysian law, and I'm also going to be talking about the role of the Consumer Rights Act 2015 and the Consumer Protection Act, which is Malaysian. Freedom of contract is one of the greatest strengths and beauties of the common law, and by extension, Malaysian law, to which English law is a progenitor. It specifically tells us that parties are free to contract on whatever they wish and are free to regulate their relationships in whatever way they deem fit, without being regimented by a doctrine of good faith, which includes a duty of disclosure. Hence, due to this close relationship between both jurisdictions, similarities may be drawn from this point of law. In English law, in the case of Interphoto Picture Library versus Stiletto visual programs, Lord Bingham threw more light on the part of the common law on the duty of good faith. He stated that English law does not have any overriding principle, but has developed various piecemeal solutions in response to demonstrated problems of unfairness. Similarly, in Malaysia, in the case of ASEAN Bankers Malaysia versus Shen Huan and others, this same view was held in the appeal to the appeal court. Here, he reversed the judgment made by the High Court allowing the doctrine of good faith. This clearly suggests that both laws are on the same page as regards this doctrine. In further examination at the statement made by Lord Bingham, it can be seen that English law has quite a number of piecemeals as to the lack of duty of disclosure. This has been extensively talked about by Kelvin. Such piecemeals include cases like contracts verime fide, wherein both parties are obliged to deal with each other in utmost good faith. Also, contracts such as insurance contracts, fiduciary contracts, wherein the nature of the contract is being examined, are all said to have a duty of disclosure. The existence of such piecemeal solutions are also seen in Malaysia, although the superiority in the development of the English law can be seen in the availability of case laws example. Nonetheless, there are still Malaysian cases which support this view. In Malaysia, as probably stated by C, the main point of authority on non-disclosure is Section 17 of the Contracts Act. This is applied in the judgment of the Federal Court Judge Justice Abdul Qadir in his judgment in Vitiating versus Hagel Engineering. He stated that mere silence as to facts likely to affect the willingness of a person to enter into a contract is not fraud, unless the person who is keeping silent has a duty to speak, or his silence is in itself equivalent to speech. The piecemeal solutions will come under the first division, which is parties having a duty to speak. In the case of Haji Ahmad versus Abdul Ghani Khan, the father conducted negotiations on behalf of the groom, while the third party represented the bride. Apparently, it was discovered that the bride-to-be had experiences of epileptic fits. This fact was not disclosed by the third party, and the defense that there was no general rule of disclosure was pulled out. Here it was held that the contract was uberme fide. The judgment of Justice Abdul Hamid Ebeng in Karapana Chelapan versus Chong Li Chin also highlights the presence of fiduciary relationships, even though it was not found in this case. Non-disclosure can also be differentiated from concealment of a fact under Section 17B of the Contract Act 1950. Also, I'm going to be talking about the effects of the English Consumer Rights Act of 2015 and the Malaysian Consumer Protection Act to non-disclosure. Although the freedom to contract has already been established, there are also protections available to the buyer. This is seen in the Consumer Rights Act 2015, hereinafter known as the CRA, which replaced the Sale of Goods Act 1979. In Section 9, subsection 1 of the CRA, it is stated that in every contract to supply goods, there is an implied condition that goods supplied are of satisfactory quality. This is also seen in the Malaysian Consumer Protection Act under Section 32, subsection 1. Also, Section 9, subsection 4A of the CRA also gives an exception to this rule by stating that the quality of the goods may be marred, but this must be brought to the notice of the buyer before the contract is made. This creates a duty to disclose defects. This can also be seen in Section 32B of the CPA of Malaysia 1999. Also, the quality of the goods is one which is determined by a reasonable man. The statutes also confer a duty on the seller where the buyer has made known the purpose of the good to ensure that all the goods fit all the purposes for which it was supplied. This is also seen in Section 32 of the CPA. Hence, in many ways, the provisions of these acts unleash greater protections to the buyer, which is here the innocent party, than any under a duty of disclosure. This is because it is easier to prove that certain products have defects and do not serve the specified purpose than to prove that the seller had known of the defects and purposely refused to disclose it. This protection of the consumer is irrespective of the seller's knowledge. Hence, this is a suitable reason for its retention, despite several comparisons to other European jurisdictions which have a duty to disclose. Furthermore, there are also various reforms to the duty of non-disclosure that makes it more suitable for contractual formation, and this will be comprehensively expatiated by my learned friend Praveen.
Thank you, Bolade. My name is Praveen, and I'll be continuing on the possible reforms for this general principle. After the thorough discussion on the principle of disclosure in different jurisdictions by my learned friends, now I will proceed to the possible reform that can be brought upon to extend the duty to disclose in order to bring equality in the contractual relationship. As it stands now, both English and Malaysian legal system has opted to impose duty of disclosure in the formation of contract. However, there are few exceptions to the general rule which has been created through common law decision in the UK and statutory provision in Malaysia as discussed above. In examining the principle thoroughly, there is still room for reform which could be done by generalizing the scope of utmost good faith agreements. One of the exceptions is the requirement to disclose information in the contract of utmost good faith, which is also known as ubi mare fide. This type of contract puts the obligation to disclose information to parties in the contract who gain benefit from it. For example, in an insurance contract, the insured is under obligation to disclose information relevant to the policy. However, the court has been reluctant in extending this principle to other types of contract as suggested by Lord Mansfield in Carter and Bow. This issue was mentioned by Lord Hobhouse in Manifest Shipping Co. Limited and Unipolaris Shipping Co. Limited as to the failure of generalization of the principle of good faith to other type of contract. The reluctance has caused uncertainty over the scope of particular principle, as there has been no general principle on the acceptance of duty to disclose for contract of such nature. There has been suggestions to revisit the approach taken by Lord Mansfield in cases mentioned above when looking at the duty of disclosure. The duty must be imposed according to the relationship of the parties and their skill, position, and knowledge in determining the degree of disclosure one party might have in such a contract. This could prevent any misguidance which might occur due to the non-disclosure of certain contractual information. Hence, reform could be done in generalizing the principle of ubi mare fide rather than it being an exception to the general principle of non-disclosure. Another reform which can be done is by changing the traditional approach and opting to impose duty to disclose as general principle. If we compare the general rule imposed on the duty to disclose in common law jurisdiction and other jurisdictions such as the civil and Islamic law, the distinctions are as such that the other jurisdictions uphold the equality and equity in contractual relationship, which undermines the rigid principle of the common law. Taking as an example, prior to 1960, the French legal system had similar approach to duty of disclosure, which had exceptions governed by statutes and the principle of good faith. The French were reluctant in diverting from the traditional rule, as various commentators expressed their opinion against such an idea, especially generalization of the notion of good faith. However, there have been divergence in the approach taken by both French and English jurisdiction, the former taking a huge step in expanding the general rule by imposing pre-contractual obligation of information in various contracts based on their status in the contract. For example, the one with specific expertise has duty to disclose material facts to the other party. Taking that into consideration, there is a possibility for the English legal system to follow the French approach by imposing the duty on certain classes of contractors. Plus, it will not be something unorthodox, as there have been instances where the common law had recognized different classes of contractors who had received obligation to the society, where parties with skills and expertise are expected to conduct dealings honestly. Need not to say the role equity has played in differentiating the status of contractual parties. Thus, this might justify why English courts should adopt the French approach to impose duty to disclose as a general principle. Next reform is under the Malaysian jurisdiction to impose unified approach to protect the interests of innocent party. As per illustration A in section 17 of the Malaysian Contracts Act, we can conclude that there is no general duty to disclose information that could be material to inducement of a contract, unless it falls within the exception as portrayed in illustration B and C of the provision. From a moral point of view, this might put the other party in a position of disadvantages, as the buyer could be exploited by the non-disclosure. But as there are few statutory provisions to protect the interests of consumers as discussed above. However, the absence of general duty of disclosure have brought upon non-uniformity when it comes to the application of the provision which contravene the provision under the Contracts Act 1950. Hence, this calls for a uniform approach which could be imposed by including the principle of unconscionability as applied in the case of Saad Marwi and Chan Hua Hua. The principle as such that it covers the requirement of undue influence and works as a principle of equity to bring equality to parties in contract. Thus, the principle could impose uniform duty of disclosure to prevent any unjust arising from failure to disclose certain information.
When my teammate Praveen presented on the reforms or possible reforms concerning the duty to disclose, he mentioned of Sharia law. And I will be presenting today on the underlying principles that govern Sharia law in terms of the duty to disclose. As we all know, Malaysia has courts governing or administering common law and also courts that administer Sharia law. This will be relevant when both Muslims get into a commercial dispute or non-Muslim getting into commercial disputes and they are willing to be subjected under Sharia courts. The underlying principle is a dichotomy of caveat emptor. The principle of caveat emptor would be that of khiyar al-ayib. Khiyar literally means obligation or options, which implies obligation and rights. Under the principles of khiyar al-ayib, if there's a duty which is imposed on the seller to disclose material defects, while material defects are hard to define, it is usually agreed on by Maliki scholars, Hanbali scholars, and Shafi'i scholars that it is a very flexible approach that should be taken. And on what is material facts and on the limitation period. There are remedies for buying a defective good when a seller did not disclose the defects is rescission. And this is based on a hadith where the Prophet Muhammad have allegedly forbade Muslims to lie or cheat, and that includes silence, by way of silence. And this is very easily contrasted with the statutory duties of a seller in Section 17 of the 1950 Contracts Act, in which the duty to disclose is not really imposed unless that silence amounts to a conduct. And also, the statutes impose a duty on the seller to exercise ordinary diligence in finding out the defect. And that differs a lot from the principles of khiyar al-ayib, in which the seller himself have absolute duty to disclose, even if he is not actively concealing the defect. And the buyer has almost absolutely no obligations to exercise ordinary diligence. He just have to trust the seller. And it boils down to trust in Sharia law. As we now see that there are two principles governing the duty to disclose in Malaysia. One is based on the common law principles of caveat emptor, which do not impose a general duty to disclose, and the other based on khiyar al-ayib, which does impose an absolute duty to disclose. Both of these principles or doctrines are on opposite end of the spectrum, and we'll be attempting to reconcile it in our conclusion. As my teammates have discussed, the statement is very true that English law and Malaysian law do not impose a duty to disclose. In our reforms that we have just discussed, we conclude that it is better that the UK follow the French system in being more flexible in their approach, as the law on fiduciary relationships is actually one that is also flexible and should be molded according to the legal framework that is presented. And on the Malaysian point, we find that the divergence of the Sharia courts and the civil courts are one that is really on different end of the spectrum, and we advocate for a more unified approach. Thank you.